I'm calling to order the Thursday, June 22nd, 2017 meeting of the City of Tallahassee Ethics Board. Note that Mr. Davis is excused. He will be back next month. First, we have approval of the minutes. Does anyone have any comments, additions, or corrections to the minutes?
I move that they be approved as submitted.
Okay. Ms. Phillips moves approval, and Ms. McNeil seconds. All in favor say aye. Aye. Opposed, nay. And we've approved the minutes. We're going to move up item 5 on the agenda on public comment on agenda items, and you're back at the podium. Mr. Wilcox, you're recognized.
Okay. Thank you, Mr. Chair and members of the board. I'm Ben Wilcox with Citizens for Ethics Reform. I just wanted to highlight an item on the Ethics Officer's Report, item number 109. I think this item involves 2 news reports that appeared in the Tallahassee Reports newspaper. The first report suggests that the city manager received a $4,700 owner discount on a catering bill from the Edison restaurant, which, as you know, is a city vendor. The report, is troubling, and I think this ethics complaint would ask for an investigation of that to assure taxpayers that he wasn't receiving some kind of personal benefit, at taxpayers' expense. The second report, also in the same newspaper, talks about a former employee of the Edison restaurant that was the sales rep who the Fernandez family dealt with in getting this wedding service and also the discount. And the sales representative from the Edison restaurant later got an unadvertised city job with the communications department. So those are, 2 stories that I think, and obviously someone asked for an investigation into this, and I think that's really what this board is here for, to find out when we have reports like this that are out there in the community, people want to know, first of all, is it true? Did it happen? And then second of all, is it a violation of the, city's ethics code? And I understand that Mr. Currington has taken the position that the city's ethics code is so weak, and kind of wonder whether intentionally so, that the loyalty oath that is in the ethics code, which reads, I solemnly swear or affirm that I have a commitment to the public trust, the highest standards of professionalism and ethics, including a commitment to the constant appearance of propriety, always putting public trust first, and never allowing personal benefit to affect my decisions and service as a public servant. So, granted that is somewhat aspirational, but if you look at Chapter 350 of Florida statutes, which governs the State Public Service Commission, there's similar aspirational language in there, but it's the law, and this language can be enforced. For instance, it says, a commissioner may not conduct himself or herself in an unprofessional manner at any time during the performance of his or her official duties. It goes on to say a commissioner must avoid impropriety in all of his or her activities and must act at all times in a manner that promotes public confidence in the integrity and impartiality of the commission. So, I know you have concerns about whether you have jurisdiction before you initiate an investigation, but I would argue that you should go ahead and conduct an investigation when there's credible reports like this. Find out whether the reports are accurate and true, and then determine whether you have jurisdiction. The ethics officer said that she reviewed the allegations, documents, and city's ethics code, spoke with the subject of the complaint, which, I don't know what the answer when she spoke with the subject of the complaint, what he told her about whether any of this is true or not. But then, the recommendation is to close the investigation. And I just don't think that satisfies, an ethics complaint that asks for an investigation into an issue. So, I thank you very much, and I do thank you all for your service on this board.
Okay, thank you, Mr. Wilcox. We had a brief conversation about this before. The thing that I have pointed out a couple times, and the board members are acutely aware of, is that we have a very narrow jurisdiction on the city ethics ordinance, which was enacted prior to the existence of this board. And we have made recommendations in the past, and I suspect we'll continue to make recommendations in the future about specific expansions to that ordinance, which would expand our jurisdiction to give us clear authority to, there are things clearly now we can look at, but all we could do would be to write a letter saying, we looked at this and it looks like it could be a perception problem, and we think you might want to give us jurisdiction to look at it or whatever. I don't know that on many of the things that Ms. Meadows-Keefe recommends closing, that all of us think that, I can say that all of us do not think that they are not issues that should come before the board. Our problem is the narrowness of our specific jurisdiction, which we will get back to in this meeting, but I appreciate your comments, and you keep telling us that. On the ethics officer report, that would be the next number 3 on our agenda. The first item is the memorandum about the activities since the last meeting. Is there anything on there, Ms. Meadows-Keefe, that you need, before we get to the 5 complaints, specific complaints this month, is there anything on there you need to point out to us, or does anyone have any questions of Ms. Meadows-Keefe?
I'm happy to respond to any questions that you all may have. I would say that it was great that the city sponsors a Future Leaders Academy for youth in the community to provide them with some job skills, and also with placements, both in city government and local businesses. And the city did ask me to come and address these students, and some of them are high school, some are in college, but about what expectations there are for them, and to familiarize them with our ethics laws and rules in the state and the city, and how important their actions reflect on the city. The second item I would point out is that Ms. Phillips and I have been working on the handbook as a project, and we hope to have the handbook draft for you to review at the July meeting, and it's been a pleasure to work with her on the handbook, and we're pretty pleased with what we've been able to come up with so far. We've got one more chapter to get through, and then it'll be open for board comment in July. So those are the highlights that I'd give to you. And then there was also the budget workshop, and there's the next commission meeting occurring Wednesday of next week. If any of you all would like to come, it starts at 4 o'clock here in the chamber, and I have exhorted that it's important to come to at least one, so I'd urge you to come. And even if you've already come to one, come to another one. Each one is different.
I would just add, what we've been doing for about the last year and a half is, because we can't meet outside the sunshine, when we've had issues that we wanted to deal with, we've been using subcommittees of one, which is kind of what Ms. Phillips is doing here. So Julie gets each of us potentially as a separate subcommittee, and we've gotten a lot of our work done in that way, so that we have something that at least one member is knowledgeable on, rather than just dumping everything on Julie's plate to bring to us. So we will probably continue to do that as issues arise that need work in between meetings. And if you see anything like that, and that particularly you have a high level of interest in, let me know, and we'll make it official, and you can work with Ms. Meadows-Keefe and bring it back to us at a subsequent meeting. So happy to do that.
Mr. Chair, I got a question.
Yes, sir.
Actually, two. The first is, what's the handbook?
It's, oh, Ms. Medowski or Ms. Phillips, either one.
I'll be happy to talk about that. We were asked, I think it's in the charter amendment requirements, that we produce a handbook. And it's designed to be not only for employees, but also for citizens, so that they have an understanding of the ethics program in the city, government ethics in general, and specifically about the board. So that's a requirement that we're putting out.
And one advantage of that is not limited by the city ethics ordinance, so we can range pretty far afield on that in terms of just good ethical behavior, good moral behavior. I mean, the two kind of blend at some point.
We're trying to make it understandable too for the public and not use very much legalese and big words. So we're trying to write it so it's clear, understandable, and easy to read.
Okay.
Second is on the complaint that was referenced by the speaker. You want to discuss that any further?
We're going to do this, the next item.
Thank you.
We've done this first page of her report, so the second page is the 5 items. So what I'd like to do is just go through them sequentially. The first citizen requested an audit of TMH. And I think they were referred to the city auditor, unless anybody has a need for us to follow up on that, since that's not really within our jurisdiction. Second one
Did
is,
they accept the recommendation?
well,
You can do it all at once?
yeah.
Or- okay.
Well, maybe not. Second one is, again, regarding TMH and a utility subsidization
Substation.
I can't read. And how it was placed on the city commission's consent agenda. That again does not appear to be anything that's an ethics violation. The city commission puts a lot of things on the consent agenda where citizens are still allowed to speak, but the commissioners don't have a lot to discuss among themselves. The third one, it was apparently at a commission meeting, a citizen was told that he wouldn't be allowed to speak a second time, and then he complained and said he should be allowed to speak a second time. He was allowed to speak. So again, that does not look like a violation, although it is something that we are hopeful that in those public meetings they'll be exercise great caution. They already have the several minute time limit. And I'm going to jump to the last one. Insufficient time for citizen input at a public meeting, and a city employee hung up. There is an expressed time frame, 3 to 5 minutes for speakers, but in this case, Ms. Medowski spoke to the supervisor, and the supervisor is going to deal with the employee, and I don't know what that will involve. It'll be between the supervisor and the employee. The one that Mr. Grant, you're asking about is this one where a city employee received, we are told, this is not a result of our investigation, but we are told our city employee received discounted services from a catering vendor who does business with the city. And that allegedly could be a gift. And then a subsequent item that occurred, subsequent thing that occurred was that an employee of that vendor was hired by the city, which is what Mr. Wilcox spoke to shortly thereafter.
Can I talk about that?
And Ms. Meadows-Keefe is going to expand on that.
Okay. I'd like to first say that the subject of an ethics complaint is due protection under 112, and we've spoken about this before, that it is the law in Florida that the specifics of a complaint not be publicly discussed until the board determines that it will or it will not pursue action on a matter. So the chair has indicated, our lawyer has affirmed, and we have repeatedly said that we will not confirm or deny specific allegations of particular complaints. What I strive to do in this report is provide sufficient information related to allegations so that the board can broadly know what the complaint's about. Then if board members want that additional information, if they want the investigation, if they want to discuss the particulars, we notice that for a shade meeting. So that's what we've done in the past, and we're probably going to continue to do that in the future. In terms of what the speaker had to say about public expectations and filing complaints regardless of whether we have jurisdiction or not, we did have several board members the last time, and the transcripts of that are public, that had an issue with agreeing to file a complaint on an issue over which the board had no jurisdiction. That did not indicate agreement or disagreement with a particular behavior. It was just, there were board members that felt like as lawyers, they cannot file complaints in a forum when they know that forum cannot adjudicate those. So those are just the comments I'd make. And in terms of documents, you would ask the question about whether the board members were provided documents. The answer to that is no. They would be provided documents in a shade meeting, and we'd have more detailed conversations about that. And I was unable to contact this particular complainant. Normally that would maybe be the first thing I do, to ask about and flesh it out, but this complaint was anonymous and had no way for me to contact the person, and they sent those articles. They may or may not have sent articles, and I was not able to confirm any content of whatever those articles may have been about.
Okay, so let's go back. Does anyone, on items 106, 107, 108, and 110, does anyone have any concerns with closing those? Okay, so we're going to close those. I got a unanimous head shake on that one. On 109, then does anyone have a preference one way or the other? I think Ms. Meadows-Keefe again recommended closure because it doesn't relate to financial disclosure, disclosure of job offers, voting abstention, or ethics training, which are the 4 items in our jurisdiction, other than the loyalty oath, and I understand there's a difference of opinion on that. But we basically, I think, at this point have 2 options. One would be to go ahead and close it, and then obviously we're going to follow up later in the meeting talking about our jurisdiction. The other thing would be to come back in our next meeting, in a shade meeting, and Ms. Meadows-Keefe will give us whatever she has at that point, and we can discuss it. So it would be the will of the body. Mr. Wilcox, you're recognized. Please.
Thank you again for allowing me to speak. Just wanted to make one distinction in what Julie was saying as far as the last determination. In that case, you were making a determination of whether you were going to self-initiate a complaint. In this case, a complaint has been filed, and so I think it should be handled a little bit differently.
That's Ms. Phillips.
Yes, Mr. Chairman, would you list again the 4 areas in which we do have jurisdiction? I think that didn't get on the record.
The city ethics ordinance, which defines our jurisdiction, relates to financial disclosure of city officials and certain lobbyists. It relates to disclosure of job offers made to city officials. It relates to voting abstention, again, for city officials. And it relates to ethics training broadly for city officials and employees. Those are the 4 areas. So, for instance, in our February letter to the City Commission, we mentioned gifts, some possible expansions of our jurisdiction would be in the area of gifts, which is not included, the area of disclosure of outside employment, which is not included in our current jurisdiction, the issue of misuse of position, which is not within our current jurisdiction, and I'm blanking on the 4th one. There was a 4th one, I can't remember, but those are all things that we, as a board, in our discussions from November through February, had identified as things that we all unanimously agreed were ethics types of issues, but not covered in the ordinance, so therefore not within our jurisdiction.
Mr. Chair, I guess I have a comment.
Yes, sir.
And I know we've discussed this before. I do understand those specific items, but certainly, this one complaint, at least as far as I can understand it, appears to go to the heart of ethics, and then when ethics are violated, you are going into corruption. And when you talk about jobs and or not jobs, but favors and financial benefit for someone based on employment by the government, certainly that falls into it. So I guess my recommendation is we do take this up, whether it needs to be shaded or how.
Okay. I'm going to take that as a motion. Does anyone want to second that? Let's do this. Ms. Meadows-Keefe, let's not close it. Let's not go in the shade next month. Let's not close it. This, I suspect, will get some more attention, and we'll just leave it open as an item for us for the moment. I will tell you, having dealt with gifts in the past, I have some concerns. Clearly, there are gifts on the one end that are of the scale that look like bribes. Then there are things on the other end. If I'm a city employee and I buy a Groupon and use it at the local ice cream shop, that's a discounted service, but it's available to everyone. I think everyone would agree that's not a gift. But I think you get into odd situations if the city is buying vehicles from a local car dealer, and I'm a city employee, and I go in like any other car buyer and negotiate the best price on a car, whether or not that discount to me, which may be a better discount than you got, because I was just a harder negotiator, whether or not that discount is a gift. Without having a specific ordinance helping us define what's a gift, I think we get into some difficult definitional problems. But at any rate, if it's okay with the board, we'll just hold this one open and let it cook a little bit, because I suspect there will be another article or two before all is said and done, just as my guess on these kinds of things. Okay, if that's all right, Ms. Meadows-Keefe. We'll go on to the 3rd item, which is our monthly budget.
There should be nothing unusual about it unless anyone has questions on it.
No questions? All right. We have before you, this is a reminder, we are we would normally be on public comment on agenda items. If there is any other public comment, I would take it now. Seeing none. Item 6 on our agenda is, am I in the right place? Yes. Oh, no, I'm sorry, number 4. Thank you. Give it to a banker, and then order single-digit numbers come in. We have the Form 1 is part of your packet. It's posted. This is a reminder that everybody needs to file their Form 1s here pretty soon if you haven't. And Ms. Meadows-Keefe, do you have any comments for us related to the Form 1?
The only individuals who would not need to file a Form 1 would be Mr. Grant and Mr. Smith, because you filed those upon your appointment. So the next time you need to file will be next July. So you get a pass for this July. All other board members will need to file their form by July 1st with the supervisor of elections.
Okay, and I would just, one comment, since it's something I've dealt with a couple different people. When you get to the intangible personal property, please be careful how you list things. If you have a brokerage account where you tell the broker invest in certain things, each of those individual investments has to be considered, not just the overall brokerage account. If it's a, an index mutual fund, then it is not the individual investments in there because you do not control them, but that's something that trips people up sometimes. And we even see state level officials filing amendments to their Form 6s for them. But they're always fun to look at, see who's the richest. Mr. Currington has a presentation for us. And Ms. Meadows-Keefe is going to play Vanna.
Julie, well, I was a little concerned about the mechanics of this, but now it's in our videotape issue. I'm hoping I'm not being paranoid.
And Mr. Currington, you're going to be talking about this memorandum, the June 7th? Mr. Currington. I don't have anything I can throw at you. Yeah.
Can you do that? All right.
Mr. Currington, you're talking about your June 7th, 2017 memorandum?
I am, but I think it would probably be more efficient to go through the PowerPoint
Okay.
first, because it is basically an abbreviated version of my June 7th memo.
Okay, I just want to make sure that people have that in front of them. Okay. And you are on, sir.
Thank you very much. As everyone knows, I guess, I missed the May 16th meeting, and I went to the transcript and was candidly a little concerned about some confusion about the board's authority. And it was arguably confusion arising out of some of my prior opinions, so I felt I had done an inadequate job in that regard. So I felt it appropriate to write this June 7th memo to hopefully clarify some issues about jurisdiction and issues of penalties. I'm going to go off script a little bit before I get into the PowerPoint, simply because before the meeting, I thought of an analogy. I think this board, like any court, has jurisdiction to determine its jurisdiction. It has a right to evaluate whether the complaint falls under the code. And if it does, then it has jurisdiction. If it doesn't, it determines it does not have jurisdiction. So how should the board do that? In the May 16th meeting, I saw a few things where I think there was confusion between whether there was penalty in a jurisdiction. Okay? And let me try to clarify by saying I believe jurisdiction is a question of whether the board has the power to enforce either mandated behavior or prohibited behavior. But if it's not mandated or it's not prohibited, then it cannot enforce it. And it has to be mandated or prohibited by this code, not the PSC laws, not Chapter 112, not the Ten Commandments, not somebody's view of moral ethics. So it is this code that controls this board's authority. And I think my opinions have made it fairly clear that, and as the chair said today, there are only 4 or 5 areas that this code prohibits. Should it prohibit more? Well, that is the policy question. And if it should prohibit more, who should do it? The city commission? This board does not have the authority to prohibit or mandate behavior. It has the authority to make recommendations to this board. Concerned citizens can amend the charter again, or they can lobby the city commission for changes. But by and large, I think at least 67% of the people in this community probably would like the city commission to add more prohibited or mandated conduct and go beyond the 5 that the chair has mentioned, or 4 or 5 that he has mentioned. So I tried to use an example with criminal law. So, because I think the average person understands criminal law. So let's talk about criminal law for a minute. A citizen complains that they're the victim of a crime. How does law enforcement look at it? They first have to look at chapter 775 through 896 of the Florida statutes. If it's not a criminal act, even if true, then they have no power to go forward. Now, we can make very de minimis arguments. In fact, this board has adopted a bylaw that says we may not penalize de minimis behavior. So there's a difference between jurisdiction and how and if you're going to penalize it. First of all, you can't penalize behavior that's not mandated or prohibited. But secondly, if you have the power to penalize because it is mandated or prohibited, then you have some judgment about whether it's de minimis or whether or not you want to, in fact, penalize something. But, so, state attorney or sheriff or someone hears about a law enforcement complaint, they have to see if there's a violation of the criminal code. Now, by the same token, this board has to look at section 2-3 through section 2-14 of our ethics code. That's where authority is. Now, let me talk for a minute and use an example. We heard earlier today. By the way, a simple example is, if there's no law against jaywalking, and they get a complaint, they can't enforce and arrest you for jaywalking. Now, we may say, well, city commissioners or public officials shouldn't jaywalk. It sets a bad example. It's dangerous. We have too many pedestrian deaths in this city. Well, then we need to pass a law against jaywalking. Or we could pass a code of ethics that say no jaywalking. But until that is done, this board would have no authority to prosecute a case for jaywalking if it's not prohibited by the code. So we're limited by the current code. So let's use an example because I think there was some confusion again on May 16th. So let's evaluate how law enforcement proceeds with an investigation. They look at the complaint, and if the facts, as alleged, if true, constitute a criminal act, then they can proceed. However, if it does not allege a criminal act, they cannot proceed. Let me go through examples of why timing can be important. Florida, for example, has adopted a trade secrets law and made it criminal now. It was not criminal in 1974. Okay? So if anyone violated what is the current trade secret law in 1973, the state attorney could not investigate it because it was not criminal behavior. And they would not investigate. They will not investigate, spend time investigating something that is not against the law. If that same complaint comes by post-74, and the acts occurred after 74, it now has jurisdiction and will look into whether or not there was a theft of a trade secret. Next slide. Oh, I've already covered that. So next, if law enforcement determines that the complaint, if true, is a violation of the criminal code, they can then investigate. But if it's not a violation of the criminal code, law enforcement will not proceed. They have no jurisdiction, and they won't spend their limited resources investigating something. Using my example of jaywalking, they're not going to investigate whether someone jaywalked because the law didn't prohibit jaywalking. All right, let me go to the third element. So, once they did investigate, and if they find there is probable cause, the act was prohibited at the time it occurred, i.e. jaywalking or stealing a trade secret, then they can proceed with prosecution. And that's the third step in their evaluation process. Then the fourth step, and this goes to the question of penalties and so on. You investigate a crime and you should evaluate whether it states a crime or not. And that's independent of what the penalties are. So penalties don't determine jurisdiction. Whether it's mandated or prohibited act determines the jurisdiction. But once you've got jurisdiction, you may look at penalties, and penalties may affect how either law enforcement, or in this case the board, decides whether to pursue a case or whether to punish it. This board, its bylaws, has said it's not going to necessarily punish a de minimis violation, by way of example. All right, so hopefully, having said that, I'm getting ahead of myself a little bit. I guess I should look at my own slides here a little bit. So let's compare how criminal law enforcement does it, and now apply that same analogy to this board. When the board gets a complaint, it needs to look at the allegations and determine whether or not, in fact, the behavior is prohibited by this code. If it is not prohibited by the code, it should not, again, use its limited resources to investigate or pursue a violation, or a perceived violation, I should say. I've written 3 opinions now that address this court's, this body's jurisdiction. And I know it's frustrating for a lot of people, but this is a quasi-judicial body. You are determining guilt or innocence and whether to penalize someone. And just as we often see in the media, people are critical of judicial activists. What is a judicial activist? A judicial activist is a judge who rules arguably based on what they want the law to be or think it should be, rather than what the law is. This board cannot be a quasi-judicial activist. You can't rule based on what you would like the law to be, or what the code should be, or what your own moral code says it is, or the 10 Commandments, your religious doctrines. This board does not enforce the 10 Commandments. You know? Someone can complain, if God forbid a city commissioner committed murder and a complaint was filed, this board did not have the authority to enforce a murder because the code doesn't prohibit it. Now, that may sound awful. Thank goodness there are other bodies that have authority to move forward. I opine that this board does not have the authority to pursue misuse of public office. Thankfully, arguably, Chapter 112 does allow the State Ethics Commission. So there may be another jurisdiction that can enforce something. But until this body adopted a code that says our employees shall not go out and murder, they don't have the authority to enforce a murder allegation. Richard earlier, or the chair, excuse me, earlier said, and I did take a note, I wasn't vocal when he asked, but he went through the 5 things the code does prohibit or address: financial disclosure, job offers, voting abstention, ethics training, and then there's also lobbyist disclosure that affects lobbyists. But so those are 5 things this code does address. That's where this board's jurisdiction lies. While misuse of office may violate everyone in this room's notion of ethical behavior, I suspect it does. You probably get 100% agreement that misuse of public office for personal gain, benefit, or privilege violates an ethical standard. But that ethical standard has to be incorporated into the code. So, and if you feel otherwise, I see shaking heads, but that is my legal judgment. I used the 10 Commandments as an example. There was discussion earlier today about aspirational oath. Again, I know it appears very technical, but I think we all know the 10 Commandments. We were also all probably raised with the notion that we should do unto others as you would have done unto you. Okay? Great. Sounds like a moral statement to me. Very, very. But if someone charged you with not obeying the Golden Rule, would you have violated the 10 Commandments? That might be an 11th commandment, but it's not the 10 commandments. You can't be prosecuted for violating the 10 commandments if you don't follow the golden rule. So this board's hands are tied. It's not necessarily that I want them tied. It's not necessarily that anybody in this room wants them tied, but it is the law. And to do otherwise would be activism, like judicial activism, to try to give jurisdiction to this board that it does not have. Again, the city commission or the charter amendment is the way to put some teeth into this city code. Well, I told Julie, so I'll explain my wandering here. I've never presented my PowerPoint before, so I keep getting ahead of myself. Now we can talk about penalties again for a minute. All right. So, if in fact the city receives, just like with law enforcement analysis, if it receives a complaint, the act of murder, the act of jaywalking, or what, if it's not those 5 areas we talked about, this board does not have jurisdiction to proceed. If we're not happy with that, the remedy is to get whatever ill-advised behavior is going on introduced into our code. If the allegations, for example, do address one of these 5 subject areas, then, and in my judgment only then, does this board and its staff investigate, use its limited resources or whatever, to see if in fact there's probable cause to believe the elements of a code violation exist. And certainly.
Would I be out, totally out?
If you're going to do that, come to the mic, please.
You know, I believe one of the options for this board is to refer a complaint to the state Florida Commission on Ethics.
Yes, sir.
And I would think that that would be a reason to go ahead and investigate a possible complaint to determine whether it would be warranted to send it on to the Florida Commission on Ethics.
Yes, sir.
Well, I react, I think that's probably a judgment call. I would not be inclined to recommend it, if you want my gut reaction, just like I wouldn't recommend that they investigate allegations of murder. State attorney's perfectly able, or the sheriff or the police department are perfectly able to investigate an allegation of murder. Here, the ethics commission can certainly investigate, but they can certainly refer it to the State Ethics Commission, which would then have jurisdiction to investigate and use their more generous resources, I think, in terms of investigation, the state attorneys, the Attorney General's office, and so on. But yes, to answer your question, I think this board could refer it to the State Ethics Commission. If in fact, so for example, the State Ethics Code does have a misuse of public position prohibition. So if this body were to determine that if those allegations were true, would constitute a violation of 112.312, then I think this board could refer it to the State Ethics Commission. But by the same token, if they didn't find the elements there, I don't think you would refer, for failure to state a cause of action, I wouldn't refer it.
Yeah, and Mr. Currington, just to add one thing, it's my understanding that the State Ethics Commission will not accept a complaint that is nothing other than a copy of a newspaper article.
That's my understanding also. I would hope this board's referral wouldn't fall into that category, but I don't know. Okay, so again, if the board receives a complaint, and it's one of these 5 areas, and if true, and if probable cause exists, then the board can prosecute. And only then if those standards are met. And even, again, it has jurisdiction. Now I go to the issue of penalties again. This board can determine if it's a de minimis violation that it may not want to use its resources to go forward. And they can null process like a state attorney can. So that's my 4th step of this process for this board to analyze its own jurisdiction. because I've not really stayed in order, I think this next slide I've already really addressed. Jurisdiction and penalties are two separate questions. Without jurisdiction, you have no power to penalize. But with jurisdiction, you have the power to penalize but may choose not to. Okay. All right, so in summary, this board's, I'm going to read this one. Maybe I'll be clearer because I've done many oral arguments. I've done a lot less PowerPoints. This is my first. So, but in summary, this board's authority turns on whether the alleged behavior violates any mandates or prohibitions in this code as adopted by the City Commission as it exists at the time of the alleged behavior. So the first question the board should ask is whether the code prohibits or mandates the alleged behavior, irrespective of penalty. Penalty is a later consideration in judging how you use your limited resources or time. Any? In sum, this board can only investigate, prosecute, and penalize violations of the code, but it cannot do so for merely failing to attain aspirational goals or moral imperatives. I'm a little hesitant to go over the next slide, I guess, but I will since it's a public record now. We can all agree that the Charter Amendment sought to instill public confidence in the integrity and transparency of its government. To the extent the current code may fall short of these aspirations, this board should continue to assist the City Commission in further development of the code, as directed by the Charter Amendment. And I do take my hats off to the people behind the Charter Amendment. I think the organizers and all well appreciate the difference between a city charter, like a state constitution, and ordinances like state statutes. And that we don't want pregnant pigs in our constitution, and we probably don't want a lot of things in the city charter. And therefore, I think you were properly trying to defer to that body that should speak in this code. And enough editorializing, I guess. Until such time as the code, get to that slide. As the code is further developed, this board may refer allegations of unethical behavior, jaywalking, murder, to an appropriate agency, or may share its concerns with the City Commission. We've talked numerous times, and this board has decided to write letters to the City Commission about its concerns, his ability to refer to other agencies, other law enforcement agencies, and finally, alternatively, the citizens themselves can once again propose city charter amendments to achieve these worthy goals. I'll be happy to answer any questions.
Any questions, Mr. Curran? Seeing none? Thank you. I appreciate it. At the last meeting, there was some mention that the chair might meet with the city commissioners about some of these issues. I will tell you, I have had the opportunity over the last month to meet with 3 of the commissioners. I'm still missing the mayor and 1 commissioner due to my scheduling conflicts. Those conversations, they were aware of our February letter. I pointed out that the charter not only requires us to make recommendations concerning our jurisdiction, but requires the commission to consider them. So, and they were all very nice, very receptive, asked me to pass on their gratitude to the board for your service. And I'm doing that, and I will try to get those other 2 meetings in expeditiously.
Chair, I got a quick question for you.
Mr. Grant.
It's back a minute. As I think about, we have been looking apparently at other ethics boards, city, county. I am sure that there is a long history, at least for some of those, of the number of different items that ought to be included in a jurisdiction, so that we don't have to make this up as we go along, number one. Number two, make it up as violations come up. And then we see what appears to be ethics violations clearly, but we say, nope, it's not on our list. Okay, so forget that, but we'll put it to the list next time. So then when it happens again, certainly we have jurisdiction. But that seems to be a recipe for chasing the tail.
It does.
And so I would hope that at some point we could then get a list or some sort of document that would help us include a couple of things that you mentioned already, misuse of position, some of those other things, clearly, those types of things. I guess I would just start with that. Is that something we're already pursuing?
Well, that's kind of what we did in the November to February period. We looked at the ordinances, at least in Florida, and they're not uniform, but in our February letter to the commission, we did, for each of our 4 recommended areas of expanded jurisdiction, we did point to multiple jurisdictions that already addressed that in their ethics codes. So we have done, I won't say it's comprehensive, but we did try not to recreate the wheel in any cases, and to make sure that we weren't asking for something that was unusual, that it was something that had been done in multiple other jurisdictions. The one that we're going to talk about here shortly is the concept of misuse of position, because when we looked at back in November, I want to say, we looked at the state commission, ethics commission's annual reports, and what we found was that the vast majority, I won't say vast majority, the largest single category into which complaints fell was misuse of position, since that covers, it could cover gifts, it could cover use of city property, it could cover a lot of things without having to list 5 or 6 specific things. That one concept, misuse of position, will get you pretty far down the road. And I think probably anything that we've been in, where we've gone into the shade, or the complaint that we talked about a little earlier, would all fall within that broad category. So that has seemed to be the one that is most worthy of our pursuit in terms of a particular topic. And we're going to talk about, based on our last meeting, we asked Mr. Currington to actually draft ordinance language. In our February letter, we made broad recommendations. We said that we think it'd be good if you would expand our jurisdiction in these 4 areas. We talked a little about them, but we did not give the commission specific language. And I know some of the questions that I had from individual city commissioners were, well, you use this word, how broadly do you mean this word? And I said, well, that's a problem in the fact that we gave you a general recommendation. We didn't wordsmith it. So if there's a word in there that can be interpreted too broadly or too narrowly, we weren't trying to write an ordinance. And I think in the future we need to correct that and recommend specific ordinance language so that we go through the wordsmithing process and try to determine specific words where there's an unintended gotcha, where there's a word that could be interpreted too broadly or too narrowly. And I think we'll try to go down that path in the future. Very specific recommendations rather than broad topical recommendations. That was a rambling answer that probably wasn't an answer. But, next on our agenda would be any more public comments? I think I already asked that one. Mr. Shelley. Oh, well, let's do, I'm sorry, Mr. Shelley, let's ask Mr. Currington if he'd go through his recommended ordinance for us. And the letter. Well, the letter, probably, and the ordinance too. So we have a letter, it says June and then _ 2017. It's to Mayor Gillum and the city commissioners, and I guess it's from me, yeah. Or you want to do this, or is Mr. Currington doing this?
Well, I can talk quickly about the letter.
Okay.
In that,
Sorry.
we drafted this letter for the chair's signature, and I've already noticed a typo. Instead of addressing, I'm missing an A, so I beat Ms. Phillips to that one. Well, I said it, I caught myself. But we did draft a letter, and it will enclose, and I see some punctuation in there too. But we drafted a letter to the commission, kind of supplementing our February report and enclosing our draft ordinance, which will now be our probably topic of conversation. We've referred the commission to other jurisdictions that have passed similar measures so that they would know that we're not wandering in the wilderness, as the chair stated. And then we've let them know that in the future, once we've done an annual report for their commission, the chair will be setting meetings on an annual basis with each commissioner and the mayor to just touch base for 10 or 15 minutes to talk about the report, so that each year, each commissioner and the mayor gets a chance to interface with the chair about the board and its activities. So that's the summary of the letter, and the ordinance would be next.
So you've got the two-page letter, which we're going to make some, assuming we approve it, we'll make a couple of commas added. And now we go to the one page that says proposed amendment to the City of Tallahassee Ethics Code, and this addresses specifically misuse of position. And Mr. Currington, I believe you're the primary author here.
That's correct.
Would you like to walk us through this?
Okay. Basically, I did review all the other jurisdictions that have addressed this question. As the chair has pointed out, a good majority of the complaints against city officials and employees is for misuse of office. The state ethics code has a provision for misuse of public position. It uses the word corruptly. It's raised problems of proof and intent. So the other cities and jurisdictions have by and large avoided that term. And Julie and I have discussed this at some length, and we think the use of the term intentionally use your position will be easier to prove. We also, some of the other jurisdictions said attempt or use, but did not add or attempt to use. So we want to make sure attempts to misuse your office are included. Other jurisdictions have said perform and didn't say fail to perform. So we want to cover acts of omission and commission. And then pretty uniform, the use of the term special privilege, benefit, or exemption for himself or herself or oneself or others. That's fairly uniform. Those terms are not uniformly defined. I have provided some definitions. I think they're advisable, but I don't think they are indispensable. The chair just mentioned how he's gotten questions from city commissioners about what the meaning of this wording is and so on and so forth. I think generally I have literally defended hundreds of statutes that are challenged for vague, for voidness, and specific is better than general, is my experience. It's better to understand the legislative intent, so to speak. So clarity, to avoid ambiguities, to avoid declaratory judgments and vagueness challenges, I think it's advisable to adopt some definitions. Every word can be found in the dictionary, but sometimes definitions of the dictionary aren't good enough. So for this board to create its own definitions, I think will assist. There have been discussions about, well, why not just cut and paste and use the state's misuse of public position? Two reasons. One, we use the word corruptly, but secondly, people do not believe the state goes far enough. I think this goes a little further, and I don't know if the term more strict is appropriate, but I think it's descriptive. This is more strict than the state code. And it would give this body jurisdiction to penalize that behavior, because it will now be mandated or prohibited by this code. This body does not have the power to enforce Chapter 112. It could be debated if it wanted to adopt that by way of example or recommended the adoption of that. But as the chair has just said, we're taking the low-hanging fruit right here, I guess, the issue that has come up. If you look at the 110 complaints the board has gotten, 99% of them don't fall within the code. I suspect, I don't have a crystal ball, but what's going to change that? So anyway, I've got some definitions in there that I think are helpful. Because in our bylaws we talk about de minimis, define de minimis, because this proposed substantive prohibition would use terms like special privilege, benefit, and exemption. I think it's advisable to adopt those definitions. I think because one definition, benefit, includes the word compensation, I thought it was advisable to define a term that is used by another defined term. So I included the definition of compensation. I included a definition for the use of the word resource. I tried to define occasional. I think we all, and it has come up in past meetings, it occurs within state employees and state officials. As a practical matter, public bodies don't fire someone or charge them with an ethical violation because they use the office phone to call their kid's school because they missed the phone call that was telling them their child is sick. Or I don't think they fired people over, you know, they had to make a copy of their birth certificate for something and they were at the office and had to get down to register to vote or get their driver's license and they made a copy on their office Xerox machine. I'm not saying that's the preferred use or should be condoned, but as a practical matter, other public bodies have a de minimis standard. But they don't define it. It's very vague right now. So this takes a little step towards defining de minimis. You know, okay, so you use the Xerox once to copy your driver's license, or you call your kid's school every 3 months because they get sick. So, but daily or routine use, I think, is past that line. But right now, there are really no lines in the sand for that. So I'll be glad to try to answer any questions.
Okay, questions, Mr. Currington?
I have a question.
Ms. Phillips?
So you've defined everything but the word others.
Anyone other than self.
Yeah, but, I mean, are we talking about?
We could say any
So-
other person.
Yes.
Okay.
Right. 'cause
I accept the amendment.
Right, the others kind of just threw me.
I have a couple. In line 2 of the misuse, the first paragraph, it says a city board or committee. And Ms. Meadows, Steve, maybe you can help me with this too. Are there things that are not city boards or committees? Is that inclusive of all of the, I'm sorry, Mr. Currington?
The only reason I mimicked the term in the charter.
Okay,
Your authority is over officials,
Okay.
employees, officers, boards, committees. It mimics the charter.
okay, then we've got it. I have a couple punctuation things on definitions. For consistency with the statute, I'd probably put them in quotes, like special privilege benefit in quotes in each case. On B, I would add a comma after the word gain before the word or, since the rest of that sentence is all one phrase, effective in favorable manner, all the way to the period is one phrase. I think a comma would help with reading. And in D, I would make all of them singular. For E, I would say compensation means, I'd add the word any. Compensation means any fee, retainer, contract payment, salary, wage, reward, other than, strike the word any, other than payment of money or other consideration.
I'm not sure I followed. So I'd strike the letter S under wage. What else would I do?
I would make all of those singular. I'd put the word, I'd say compensation means any. I'd add the word any there.
Okay. Fee will be singular.
Yeah.
Retainer is already, contract is, salary is, wages I'll make singular. Anything else?
Strike the word, on line 2, strike any. Wages, reward, other than. I'd say reward other than payment, so I'd strike any and put than after other. And then after the comma on line 2 where it says any other consideration, I would strike the word any, because we've added any at the beginning of the sentence.
No pride of authorship here.
Well, that's, you know, being extraordinarily picky. And then I assume on E that your intent would be that if we do recommend this to the city commission, that we would leave the dollar value blank.
And that was a pure policy consideration. I mean, you know, you could make your recommendation on that or stand silent, either way.
I mean, I'm personally fine with it being a blank, because they have some other standards that relate to how they do business today, and I don't know that we're trying to interrupt the normal course of business as it's conducted. We're just trying to make sure that business is conducted outside the normal course, so we have some jurisdiction.
just FYI, in doing my research and all, you know, gift law is $100, I think, still, or at least it used to be, unless you work for a particular governor who might drop it down to 0. Some of these local authorities had $5 in there, so it runs the gamut.
Comments, questions? So I guess the issue before us is whether we want to make the, now again, we made a recommendation in February, a generic recommendation that we thought our jurisdiction ought to be expanded to include misuse of position. So the question is whether we want to follow up here in June with a specific recommendation. So that's what we're going to be talking about. So this is now where I will finally get to the city attorney. So Mr. Shelley. At the mic, and I'm sure just overjoyed to be here.
First of all, there's been a lot of discussion about the lack of jurisdiction and authority to deal with certain kind of alleged violations of ethics provisions. I'd suggest that you folks are missing the boat on the most obvious thing to do, which Mr. Currington touched on at the end, is to refer it to the State Ethics Commission. Now, they don't take anonymous complaints, that's true, and they don't self-initiate. But if you got a signed complaint on misuse, why wouldn't you refer it to the Ethics Commission? Just like if you've got evidence of a complaint and a crime's committed, I certainly hope you're going to refer it to FDLE or the Sheriff's Department to investigate. If you do that, you establish that there is a need to have this additional jurisdiction. You haven't, and I know, for example, that other jurisdictions that have separate local ethics board, they do in fact refer it to the State Ethics Commission. So why in the world, if you have on its face a jurisdiction of misuse of position, wouldn't you send it to the Ethics Commission? Because I think that gives you a lot more credibility in terms of looking at state law, number one. Number two, taking some action beyond just dismissing it. And from my perspective, and I think Mr. Wilcox as well, it's pretty obvious that that is an action that you can take to establish that there is need for additional authority in these areas. So that is my, I don't think Mr. Currington and I disagree on that. Now, it may not, you may not be able to refer certain things, anonymous complaints. Somebody's not willing to sign the name, but most of your complaints are not in that category, I don't believe. So, anyway, I think also our commissioners, my commissioners, will think there is in fact a need, rather than just the declaration, well, other jurisdictions that have separate boards, they have this, so we need it too. You can establish that there in fact is a actual concern and ongoing issue in this community that may need additional jurisdiction and may need to be more stringent than state law. So that's my thoughts on that. Now, if you will, first of all, Mr. Herring, you keep referring to the February letter. The letter that I'm aware that went to the City Commission was dated March 2nd.
Well, we approved it in our February meeting, so that's why I associated with February.
Okay, so the commission it was hand-delivered, I think, to each of the commissioners. And I think it is certainly true that each of the commissioners has considered those letters. I know I've had one or more conversation with each of the commissioners about your recommendations. And I think that I can report to you that you made recommendations in 3 different areas, and there has been, I believe, significant change or progress made in some of those areas. For example, your first one was in city policy and procedures. And one thing that has happened, and our HR director for the city is on the agenda tonight, and she will report that the anti-fraternization policy has been adopted by the city. She will also report that we're into the final draft stage of an outside employment policy. And there's consideration going on right now in terms of revision of the gift policy. So I don't want to give, for you to have the misimpression that the city's not listening to you or not taking any actions on these things that you have referred to in your March 2nd letter. Now, with respect to lobbyist registration, both as a policy and as a potential ordinance, my commissioners have generally said, look, the city has been, through the treasurer clerk's office, dealing with registration of lobbyists since 2011. And we have had several occasions where lobbyists, as defined under our policy and our ordinance, were not registered. In every situation when that was brought to the attention of a person that wasn't registered by the treasurer clerk's office, the lobbyists did in fact register. Whether it was lack of knowledge or whether it was just inadvertent or whether they didn't want to spend the money, there's been not a single one that we've had to even a second time have to suggest that entity register. So based on that, the commission is hesitant to change that. They think that what has been going on, and the treasurer clerk's staff is not at all hesitant to point out and to check speakers and contacts being made with commissioners to point out that lobbyists do in fact have to register. The suggestion, moving on to other items, the suggestion that we don't use ethics training but use ethics education, we're totally fine with that. I think that Ms. Phillips made a good point there. And so we have started and will continue in the future in terms of the city's training program, not use the word training, but use education programs. The commissioners have asked me as the city attorney to, and I've begun to do this, to make contact with attorneys, city attorneys in the areas where there are local jurisdictions, in Miami-Dade, in Jacksonville, et cetera, to discuss with them their additional ordinances and language and their views on whether or not that has been a positive or negative. My commissioners are always concerned that if it's not going to be a positive, it could be a negative. It could be a negative in terms of folks running for office or in office caught between not knowing how a new local ordinance is going to be interpreted and relying on state law where there's been 20 years of decisions made and knowing what the terminology means under the state ethics law. But we're in the process of doing that. And certainly, if you adopt the misuse of position language proposed by Mr. Kern, we'll specifically deal with that in terms of the jurisdiction that have the closest language to that. I think it's largely the change from corruptly to intentionally, and see what difference that is made. On the charter amendment, there continues to be an expressed need to fill the 7th position. I will tell you that most of the commissioners haven't seen that as a huge issue because they haven't, at least publicly, seen a tie vote. But I think there's certainly willingness to start an amendment process on that point. I think our commissioners generally would not want or would not propose that the 4 appointed members appoint the other 3. That doesn't seem quite balanced. But there are certainly other entities in the community. And if you look at Miami-Dade local charter, ethics charter, the Florida League of Cities appoints a member to that. In some areas, a Chamber of Commerce representative is there. So I think we can probably come up with a entity to appoint a 7th member that would be agreeable to the board and also agreeable to the commission, and we could start the process on amending the charter. And it may well be that the best thing to do is just to remove the judicial appointment, since now we've had 2 chief judges refuse to make that appointment, and I think there's no reason to believe a 3rd or a 4th would treat it differently. And I don't think the folks that brought us the charter amendment would be opposed to that. The overriding focus that the city commissioners have when they consider actions of this board is, I think, best, and I've said this previously at this podium, is the education aspect versus the prosecution aspect. I think Julie's law review article, a couple of footnotes said it best. And I'm quoting from footnote 134. Enforcement action and fines are not an ethics commission's successes. They're its failures. I think that's very pertinent when we spend all the time and energy on talking about expanding jurisdiction in particular. I'll be glad to answer any questions I might have.
Questions for Mr. Shelley? I have 2 comments. One on the appointment. I can tell you, at least for the board members who were here at the time, which is not the current board, but in terms of a 7th member, we were interested in a 7th member, we weren't tied to any particular appointing authority. So anything that would happen there, it would not, as long as it was obviously a credible person or organization. But we were sort of interested in that odd number. And on lobbyist registration, a good part of our discussion was not so much about making more people register to lobby or tightening up those who are currently required to lobby, as it was clarity to people who clearly don't have to lobby. So if say there's something that involves a neighborhood association, and I happen to belong to that neighborhood association, or something before the city commission that's going to affect the church to which I go, and I'm a member of that church's congregation, and I want to come up here before the commission, those people would never, because they're not paid, would never be required to lobby and to register as a lobbyist, and therefore that should not even be a consideration. A good part of the discussion was how to alleviate any concern among those people who should not be required to lobby, that they not ever have to worry about that, and being crystal clear on that point.
I think on that point, certainly the city would be open to changing its policy almost immediately to make those kinds of what I would consider obvious exemptions plain stated in our city policy. And I'll certainly take that back to the treasurer clerk and see if we can have that happen.
Yeah, I think on that one in particular, I had a discussion with one of the city commissioners about that specifically, was that we did not have examples of problems with people who should lobby, or who should register to lobby, getting registered. It seemed more an example of people who were concerned about whether they would have to register to lobby, and that it might have some, albeit minor, but some chilling effect on people's willingness to appear.
Right.
So, questions, comments? Mr. Shelley, as always, thank you. I'm going to...
Would it be possible for me to?
Please, yes, yes, absolutely.
Thank you. I had thought that I might do this for non-agenda items, but this is what I really came to discuss. My name is Peter Butzine. I'm a city resident. I represent Common Cause, and I'm part of the Ethics Coalition. I congratulate Mr. Shelley for being an outstanding attorney to the city commissioners, whom I would point out he referred to as my commissioners. However, I would like to suggest respectfully that his service as city attorney may fall short of the mark. My point is that while he represents the interests of city commissioners, those interests are not always aligned with the interests of the 67% of city electors who demanded strong enforceable ethics code and campaign finance reforms. Mr. Shelley has opposed their efforts from the beginning when he challenged the petition initiative. I think it would be absolutely inappropriate for the League of Cities to appoint the 7th member of the board. I have worked with the League of Cities since the 1970s, and I can tell you this organization has consistently opposed strong ethics codes and financial disclosure for local government. From the beginning of this board, city commissioners basically told us, how dare you suggest that the ethics code be strengthened and enforced by an independent board? There are no ethics problems in this municipality. Well, since then, it has become apparent that our city, while perhaps not as plagued by corruption as municipalities in other parts of the state, we do have some troubling examples of misuse of office, public position, and conflicts of interest in the city of Tallahassee. I would point out just today, the Tallahassee Democrat reported in its online edition that federal authorities have demanded the city of Tallahassee produce volumes of records related to top local developers who built some of the biggest projects financed by the Community Redevelopment Agency. The FBI and the U.S. Attorney have issued 2 separate grand jury subpoenas to the city of Tallahassee and the Community Redevelopment Agency seeking evidence to present to a grand jury. While this is certainly a long way from a formal investigation, much less a legal violation, it suggests that our city may not be as devoid of public impropriety as Mr. Shelley and city officials have suggested. What is most troubling, if not appalling, is that the commission apparently has no interest in creating an enforceable ethics code. Now, my beef obviously is not with this board, although I've got to admit that I was surprised that Mr. Grant's motion did not garner so much as a second. But regardless, I'm very disappointed with the city commission. The city is spending in the neighborhood of $300,000 on an ethics board that has been found to essentially have no enforcement powers over an ethics code that has been identified as being primarily aspirational. I, for one, plan to attend the next meeting of the city commission. I will use my 3 minutes to point out the city's failure to provide this board with the tools to do its job. Nevertheless, I deeply respect you for your service to this board. Thank you.
Mr. Betzine, any questions, Mr. Betzine? Seeing none, thank you, sir. Okay, so the issue before us is we have a draft, this again came from our last meeting. We have a draft letter and a draft ordinance, which either we can have considered and we can let just sit till a future meeting, or we can move forward and send to this. Ms. Phillips would like to leave it to let it percolate until the next meeting. Is that a motion?
Yes.
Okay, so I have a motion. Is there a second? Okay, we don't have a second. We may not have a, we're having trouble with seconds tonight.
I would like,
Please.
I'd like, you know, I was appreciative that we now know what's been going on, or the result of our report and our recommendations, so I appreciate knowing that. And I'd really like to do some more research myself on, you know, where where we can refer to other jurisdictions, other than the ones that we have that are enforceable in the code. I do believe that there are some things that we should add, but I'm not convinced that what we have in the letter as an addendum for our suggested language is where I want to go at this point.
Okay. Other comments? Motions? All right, I think this is something that will be back on a future agenda, I guess.
So are you gonna come back and make recommendations to what you find, or?
Yeah. I want more information.
Let's do this. We'll put this issue back on the next agenda, and I'm going to ask Ms. Meadows Heath if she will go through our March the 2nd letter, and do a kind of maybe 2 columns, what we recommended in brief and what has happened or is happening on an issue by issue basis. Is that a reasonable request of you?
Yes.
Okay, so that we'll have that more comprehensive look at a follow-up to our work the end of last year, beginning of this year. Does that meet with everyone's approval?
Mr. Chair, can you put that in more simple English for me so I can understand that?
We're going to take the recommendations that we made to the city in our March the 2nd letter.
As to the expansion of jurisdiction?
Well, it was a bunch of things. It had to do with, we made recommendations concerning what we could do internally, what the city might do in the way of policy, what might happen in terms of ordinance changes, and what might happen in terms of city charter changes, so that we had different categories depending on how various issues would need to be addressed. For instance, the 7th member would have to be a change to the charter, so we had all those categories, and under each of those headings we had multiple recommendations. So what she'll do is she'll basically summarize those for us and then put a status on each one. All right, with that, we're going to take a 15-minute break.
I have looked at it again. We now meet.
Yes, thank you, Mr. Chairman. So, I'm a very thoughtful person, so I have to think sometimes. And I know that Mr. Currington had drafted the proposed amendment to the city's ethics code. And I need to think about it. And I also would like a little bit further explanation, if possible, today, regarding the process, if we, and maybe a reconsideration of addressing this issue tonight.
Okay.
The proposed amendment. But I do need some explanation regarding the process, this process versus us sending a complaint to the Commission on Ethics. What this says versus what the other process is.
Well, let me take a stab at a couple things. One, when you read the charter amendment, it requires, it uses the word shall, requires us to make recommendations to the city commission concerning the city ethics code. And it requires the city commission, not the individual commissioners, but the commission to consider those recommendations, which I believe when you mandate that of a collegial body, it has to be the collegial body that does the consideration. So this recommendation, much like our March the 2nd letter, this would fall under our authority, responsibility under the charter to make recommendations in areas that we believe are related to ethics. It is really nothing different from what was in our March the 2nd letter, in terms of the topic, other than it is more specific because it includes specific language. So it has, the wordsmithing has been done. So we would have spent the time that Jerry has spent and Julie has spent, and then we have spent as a board looking at the specific words and making sure that we're happy that there are not terms that are misused or that are overbroad or underbroad. The issue of referring complaints to the state commission, there are, it seems to me, two, maybe three primary considerations. One is their jurisdiction is clearly under the state law, so what we're recommending is slightly different from the state law, so there would be that difference. Ours would be, as Jerry says, broader because it would be intentionally rather than corruptly, and the state law has had that problem of you have to prove not only that the person did it intentionally, but they did it intentionally with malintent or corruptly. That can be very hard to prove. So we're trying to address that somewhat broader issue. And the second thing is the issue that Mr. Davis raised last month, that as an attorney, he feels like if we refer a complaint to the state ethics commission, that we should have, that we are putting our name on the dotted line that complaint is true and accurate to the best of our knowledge, and implying that we have some knowledge. So that would require, in a situation where we clearly have, or where arguably we have no jurisdiction, it would require us to go ahead and do an investigation of sorts. And I don't know, once we get into that our bylaws really address the due process aspects of that, whether it would simply be a shade meeting where we look at whatever information Julie's been able to get for us, or whether the person about who the complaint is being made would have a chance to respond. It raises those issues as we think about simply referring some of these things on. If we got a complaint that on its face could be filed directly with the State Ethics Commission, we could simply refer it. The issue that came up tonight could not be referred for two reasons. One, they won't take anonymous complaints, and two, they won't take complaints that are simply newspaper articles. So we would have to do some work which puts us in a position of really that we are the complainant. We're not passing along the complaint. Like if Julie got a complaint that a murder had been committed, she would immediately pass that on to law enforcement and the state attorney without doing any further investigation, because it would rise to the, and they would make those decisions. But we're not the complainant in that situation like we would be if we make a complaint to the State Ethics Commission. So that's kind of rambling. Ms. Meadowski.
Okay, I think the thing Sonny wanted, or Board Member Phillips wanted to have addressed is process-wise, where would this board and the process go from here if the board were to move forward with this draft ordinance and go ahead and send the letter to the mayor and commissioners along with the draft? So what would happen next? Process-wise, what would happen next is this draft ordinance would then become the responsibility of the commission and the city attorney. But as you recall, when we dealt with penalties, Mr. Currington and Mr. Shelley worked together, lawyer to lawyer, to negotiate and draft terms and penalties that were acceptable to both Mr. Currington as our lawyer and the city. So it would turn into basically a lawyer-to-lawyer interaction where the board would approve the language, and then Mr. Currington and Mr. Shelley would come together to see what product could be produced that Mr. Shelley could put in good conscience, I guess, in front of the commissioners for a vote. So that is process-wise what would happen. And the end product of that negotiation probably would come back in front of y'all to look at to see if you felt that was sufficient. But that's what the process would be. And I have a note at the next meeting to do a quick presentation on the mechanics of referral to the State Commission on Ethics, since we have talked about that. I'm going to go through the form that must be filled out, and I will say that whomever signs that has to do it in front of a notary. We're loose with our requirements for complaints. We don't require a name or an attestation. Someone here would need to do that. And there may be concerns about that if we're questioning the veracity of, say, a newspaper article. Someone may not be comfortable saying that to the best of their knowledge they swear or affirm that these facts are true. So who would that be on the board? We need to have a discussion and a bylaw probably on that, because especially those that are attorneys, they would probably take that oath kind of seriously, that to the best of your knowledge you're seeing it's true. So that's the plan and the process. So if that answers your question between the chair and I.
Yeah, and I want to be real clear on one thing. It is not our responsibility or our authority to amend the city ethics code. It is our responsibility and our authority to make recommendations concerning that. Once we've done, I mean, there's to me a hard line. We make recommendations. We're done. We do not control the city commission. We should not control the city commission in terms of what they adopt as ordinances. They're going to do what they do. The ball is in their court at that point. The only thing that we do, and that we did in our March 2nd meeting was, or March 2nd letter, was say in these broad areas, city policies, city ordinances, charter, and our own policies, here are some things we think that would improve the ethics environment in the city. So to the extent we made in that letter recommendations about things we ought to do, we've done those things. To the extent we made recommendations about things the city ought to do, that is now theirs. We've owned what we can do, which is making recommendations. And I'm certainly not going to take any responsibility beyond that.
Chair?
Mr. Grant.
Question. So my understanding of this is that we are handcuffed by the fact that we have not jurisdiction or limited jurisdiction over a number of areas. And the only way we can get further jurisdiction is to go to the city commission and get them to do it. I'm not sure, I'm not an attorney, but I would think that the city commission would fight every effort to do that, because then it would make life more difficult for them. In which case, we can continue to make recommendations, but they can continue to either ignore them or not take them. And if that is the case, ultimately, then we are back to square one. And then what then does an ethics board consider in terms of ethics violations. And I'm just asking honestly because I don't understand. I'm trying to follow the discussion and the argument, and I understand what you're saying, and I would agree with that. I would agree that if they don't take it, we wouldn't have the jurisdiction, which would make the argument that perhaps we need to take our own jurisdiction at some point on some of these things, whether it's letters, actions, or referrals to the state, or do something. In other words, because if not, then you are faced with a number of alleged ethic violations, but then say, oh, we can't do it because it's not here. And then the people who pass these things and the citizens go, well, what the heck? I mean, what are you doing then? Why is there an ethics board? What do you all do for a couple hours here? I mean, if you're not even going to consider a couple of what I would consider major, at least alleged violations of ethics. Does that make sense?
That is an eloquent summary of our conundrum, yes, sir. And in my view, the two things that we have that we can do on topics that are clearly not within the city ethics ordinance are refer them to some other body that we believe has jurisdiction, or write letters, make recommendations to the city. Now, and it may not be a recommendation for an ordinance. I mean, we made some recommendations concerning city policies that we thought were things that they didn't belong in ordinances because they could be handled in other ways. There are some things, for instance, some things in ethics training that you can do by policy that are fine, and you don't need to have an ordinance. While you have an ordinance that says people have to go through ethics training, any more detail than that is fine, it would seem to me, to be in a policy. And so we've made recommendations in those areas too. I think we're kind of playing this by ear. We're a couple of months into this, making hard recommendations process and seeing what response we get.
Mr. Chair, I would point out that in the history of the board, I think this would be the first time that the board would advance draft ethics language to the commission. We did do that for policies. Mr. Currington and Mr. Shelley did a negotiation, and ultimately the commission did pass penalties that the board can assess. So this would only be, in the history of the board, the second time that this board's advanced a recommended policy. So we don't have a track record yet of how the commission will respond. So I think it's appropriate to consider giving them that opportunity based on the fact the first time the board did it, we had a measure of success in that we now have penalties, which we lacked before. So we don't have a history of them saying no, necessarily.
For the newer board members who weren't here when we did that, the charter amendment says that we could have the ability to penalize people as provided by ordinance, and there was no ordinance at the time the board was created. We looked at other jurisdictions and best practices and came up with a list of potential penalties varying from very minor to relatively significant. And I would say, and Mr. Kern can correct me if I'm wrong, that what the city ultimately adopted was probably 85% of what we had asked for. So that's the one time in the past that we have made a very specific recommendation to them, because it was a list of specific, a penalty, a fine up to this amount, a sanction in this format, and they adopted most of that. And I think they only added one thing that we didn't ask for. They took out maybe one or two of the most severe penalties. Mr. Currington.
I very much want to try to stay on legal advice, and forgive me if I exceed that, but I want to try to address a couple things. One, to Ms. Phillips' question. In this context of, it seems to me we're getting a rhetorical question, why do you need to adopt, or why does the city need to adopt a misuse of public position when you can just refer these to a body that already has that power? And I think the answer is because you're referring it, arguably, in some people's mind, to a flawed system. The chair already pointed out that it has the word corruptly in it, it's harder to prove, and so on, so it's harder to enforce that ethical standard, number one, by a referral. That's one problem. The other problem is, arguably, this is a better product. This body has the ability to propose a better product than Chapter 112. By way of example, 112 does not address failure to perform a duty. So you're filling a gap. So this is arguably a new and improved version, and why you don't want to just refer. And thirdly, it doesn't address, the state statute doesn't address definitions, like it doesn't even define special privilege, benefit, or exemption. Now, if we could for a minute talk about that from a legal implication perspective. My initial draft, and Julie and I discussed this some, at one point I drafted something that gave some examples, because people love examples. Now, there's a problem with a list of examples. There's a legal theory that the inclusion of one is exclusion of others. So if you say, well, here's 6 examples, and a good example of that is the gift law. There's 2 pages of this shall include, and gift doesn't include this, and it gets very long. These definitions, decided not to go that route, because it can get very long and very wordy. But secondly, hopefully the definitions would allow you to apply the definitions and be able to create that list on your own, I think. So I think definitions are better than examples, okay? Because you can come up with 100 examples or 100 exclusions. Now, as to Mr. Grant's concern, if we make recommendations and the city commission doesn't adopt it, and we can, whatever their sentiment is, part of my response is, and this is going a little bit beyond the legal argument, but I can remember the criticisms of Chapter 112. And my observation, historical observation, would be the legislature wasn't excited about that one either. Public pressure. It got passed because of public pressure. Why does the President of the Senate or the Speaker of the House adopt or stiffen up their penalties or their gift limits or whatever it may be, or whether you can get a free lunch or whatever, Senator Lee, whatever. Hundreds of examples. Ultimately, it was public pressure, constituency. So maybe we'll be pleasant surprise. Maybe the city commission will respond favorably. Who knows? And my last observation is sort of political commentary. This is democracy at work. It ain't pretty. It ain't efficient.
Thank you. Comments, questions? Mr. Grant.
Sir, one quick follow-up, and I don't want to belabor this, but to Mr. Currington's point, absolutely, I couldn't agree more. Public pressure is a way to get things done. And so the way that this board could do public pressure, I'm sure you can think of many ways, and I can think of a number of ways, whether it's letters, whether it's media, whether it's just, getting the word out that we would like to address these issues, or we are addressing these issues even without jurisdiction, and then force the issue at some point. Now that's one course of action, and I understand we're going the other course of action now, and I understand that, but at some point we may want to consider that.
Ms. Phillips.
I like to believe that everyone is doing their job and doing it ethically. I understand that sometimes that's not the case, and we have to have something in place to prevent it, which is part of our education, or to stop it. We've already gone through, our recommendations as part of the report. This is just a follow-up to that report. So, I think it's done.
You think it's on?
I think we should move forward with this.
So you are, we had not passed any motions on this, so we're going back to item 7. So you are moving that we,
I'd like to
that we get a towel.
reconsider it.
She's down there laundering money. Sorry, I couldn't help myself, which is just really sad. So you are moving that we, with the minor changes, the minor tweaks, grammatical tweaks that we've made, that we go ahead and send this letter and this draft ordinance to the city commission.
I'm saying we should reconsider our position to delay it.
Okay. Can I take that as a positive motion? Are we just moving to reconsider, or do you want to make a motion that we send it in June?
I'm moving to reconsider.
Okay, you're moving to reconsider. Do I have a second?
So
she is moving it to move forward.
Yes.
I second.
Okay, Ms. McNeil seconds. So all in favor say
Wait,
aye.
before you take, let me understand what the motion is.
This would
I
allow
thought
us
I
to-
heard send it, then
No.
somebody said, no, let's hold it and then send it later. So are we sending it now or sending it later?
We had previously
motion
made
for?
a decision to hold it till next month. What this would do is put this back in front of us to determine if we
Gotcha.
want to send it this. So we're
In that case,
reconsidering.
Okay. I
So
We're reconsidering.
All right.
all in favor say aye.
Aye.
Opposed, no. Okay, so we are back on, we have in front of us the June _2017 letter and the proposed amendment to the City of Tallahassee Ethics Code, both of which have purely grammatical changes, which are on the record. Ms. Phillips? Am I putting this back in your lap? I'm not sure where I am at the moment.
I've made notes of the grammatical issues in the
Right.
letter, and I know Mr. Currington's made notes related to the language.
Okay, so let's assume that we have that corrected in front of us. Now, so the issue, I guess, we'll go back to the issue that we had before. Does anyone want to move that we move forward, that we go ahead and send this?
I move that we send this.
Okay, Mr. Grant moves that we send this month. Do I have a second?
Second.
Ms. McNeils has a second. Is there discussion, debate, amendment? Anybody have rotten fruit to throw? Okay, all those in favor say aye. Aye. Opposed, like sign? Okay, so we are going to, with the edits. Oh, I'm sorry, yes, we have public comment. I apologize for not looking up.
That's no problem. And thank you very much for your generosity with your time. I know it's been a long evening here. I just want to say that our group, will be fully in support of this proposal to the city, and we're going to plan to be at the City Commission meeting next week in support of it. And I also just wanted to say that I think Mr. Shelley kind of gave you the green light to pursue the avenue of referring complaints to the Florida Commission on Ethics. I'm not sure that the Ethics Commission has a policy about not accepting just a newspaper article. It has to be a sworn complaint. The Florida Elections Commission requires personal knowledge of a complaint, but I don't think that the Ethics Commission has that same requirement, but I'll check on that.
Well, Julie's going to walk us through that at the next meeting, so it'll be on, the materials will be on our agenda.
Okay.
Absolutely.
Excellent.
We'll be sure that, and I could well be wrong, because those ethics elections, they kind of sound alike.
I think that could be a good remedy, for the problem of, you are the Independent Ethics Board of Tallahassee. You report, Julie reports to you, but you report to the citizens.
Yes, sir.
And when a citizen brings a complaint to you, I think they deserve an investigation of that complaint and consideration of referring it on to the Commission on Ethics if you don't have jurisdiction of it.
Yes, sir.
Yourselves.
Thank you.
Renee has to go.
Ms. McNeil is excused. We have, finally, we're going to get to fraternization policy. Ms. Blair has been profoundly patient with us, although I suspect we may not get dessert after. You can just-
Good afternoon, Ellen Blair. I'm the Human Resources Director for the City of Tallahassee. So, on your agenda is finally the anti-fraternization policy that we bring before you. You should all have gotten a copy. That has gone through an extreme vetting process through the city manager, through major department heads, and we are adopting it, and we are here to tell you that, and we'll be communicating it to all of our workforce. So I'm here to answer any questions that you may have.
Questions? From Ms. Blair?
Just a comment.
Ms. Phillips?
We're glad to have you back.
you.
And thank you for so much for moving forward.
Absolutely.
With this. And this is going to be on the agenda.
This has been adopted. It's been
Okay.
adopted through the city manager. We just wanted to bring it in front of you
Okay.
first, and now we're ready to disseminate it.
Okay, great. Thank you so
So
much.
thank you. I didn't know if you wanted to, Mr. Shelley already spoke to the fact that we are going to be, and we're in the process of changing our policies for both the secondary employment. We already have a policy, but we will be amending that policy to add in a form where employees are going to be required to attest to the fact that they feel that they are not creating a conflict of interest through any such secondary employment. That will go in front of their supervisor, who will review it. And that will also give us an opportunity to track that and give you or us the opportunity to provide additional education in that area.
And if I may, it's the responsibility then is on the employee as their secondary employment status may change in the future. The responsibility is continually on them to update that
Exactly. And
as changes occur.
exactly. And in fact, we're going to build in, we have this annual critical review policy procedure in place now with certain policies that are reviewed and required by employees to review and sign off each year. And we're going to add this into that. So they'll be reminded on an annual basis to self-disclose and make sure that we have the information so we can track it.
Back on the fraternization policy, I had one question. I've worked in several environments where you spent a humongous amount of your time at work, and your friends were at work, and there were numerous romantic relationships that developed. To the extent that people are co-workers or maybe they don't even work in the same unit, was there pushback on that? I know in here it says that you should just report to your supervisor if something's going on, and that can be.
Yeah, so the policy really is twofold. It was developed primarily to address supervisors and managers having relationships, intimate relationships with subordinates, but it also is developed to address peer and coworker relationships. So we do spend a lot of time together at work, and we're human, and relationships do develop, but when it starts to interfere with their ability to work or our ability to run smooth operations, that's when we would address that.
Okay, thank you. That seems consummately fair to me, because the people you know best are probably the people you want to hang out with.
Yes.
Thank you.
Thank you.
Much appreciated.
Okay, thank you.
Richard?
Sure. Oh, sorry, Mr. Currington.
On a lighter note, if I could, in light of my 3 opinions, my PowerPoint, can I give the board a pop quiz here? Would the board have jurisdiction to enforce this personnel policy? You don't have to answer it, I'll answer it for you. No, unless this board adopts this personnel policy or recommends the adoption of the personnel policy and the city commission puts it in the code of ethics.
Right.
But the city does.
Right.
Or the charter's amended, let it, you know.
Right. But again, I think that this was in our recommendation, and I think it was probably in the works anyway, but this was one of our recommendations for the city to consider in terms of policies, because there are going to be a number of places where we think the ethical environment in the city can be improved without having to expand our jurisdiction simply through policies and reporting. And I certainly don't ever want to take that off the table for us to make recommendations in the area of city policy in addition to or outside the area of the scope of our jurisdiction. Mr. Fletcher. He was going to
Make
talk
sure
to us
that-
about the audit, the follow-up audit on Big Bend Community Development Corporation.
Do you have a PowerPoint?
I have a 25-slide PowerPoint, but I guess I'll go ahead and get started unless they come down and get it going for me. Anyway, just seemed like it was a couple months ago I was up here presenting this audit, and now it's time to do the follow-up work. So, anyway, as a refresher, as a result of a meeting that Ms. Meadows Keefe and I had with some citizens, we did an audit of the Big Bend Community Development Corporation. We addressed both loans that had been outstanding for several years. At the time we started the audit, the outstanding balance, I think, was about 1.3 million. And we also addressed some of the grants that the city had awarded to the Big Bend CDC, and we identified several issues during that audit. And just to quickly
There we go. I was going to send Mr. Currington up to give you a little hand.
I set the bar pretty low.
To quickly go through those issues that we identified, we found that agenda items addressing some of the initial loan authorizations or modifications to those loans were not, some of the facts were not properly presented in agenda items. We found that a contract was not executed in accordance with the city commission authorization. We found that the records at the city were not sufficient to show that the loans had been used for authorized purposes. And as a matter of fact, we found one instance where loan proceeds of $20,000 had been advanced to pay the same cost twice, which in essence represents a duplicate payment. We also determined that for one loan that required mortgages to secure the city's interest in the rehabilitated properties, that the mortgages were not obtained by the city. We found that the city had not verified that the Big Bend CDC had obtained appropriate insurance coverages on some of the properties that were mortgaged. And we found that the projects to be financed with the city loan proceeds, for the most part, had not been completed to date. And we also found that the city's oversight and monitoring of these loans needed some significant enhancements. As to the grants that were awarded by the city, we found grant funds totaling approximately $27,000 out of the $141,000 that had been reimbursed pursuant to those grants for question costs, meaning they had been spent for question purposes, unallowable purposes, or inappropriate purposes, or there were no records to slow down here. There were no records to substantiate what the funds had been used for. We also determined that the Big Bend CDC executive director had hired his daughter to help administer the grant-funded activities, which was in direct conflict with the nepotism provisions that govern those grant funds. We found that the Big Bend CDC had limited success in achieving its contractual goals related to providing the revitalization services to low-income persons, and that was attributable, at least in part, to the lack of financial resources to which the Big Bend CDC had. And we found that the department, of course, needed to make significant enhancements to the process of reviewing and approving grant reimbursement requests. As I've indicated to you in the past a couple of times, we do follow up on our audits. We follow up twice a year, once at the end of March and again as the end of September. So as of the end of March, there were 14 action plan steps of the 18 that were developed for this audit that were due for completion. So this first follow-up covered the status of those 14 action plan steps. And what I'm going to do, try to do it quickly, is address each of those 14 action plan steps. Some of them I'll address individually, and some of them I'll address in the aggregate to move us through this quicker. So the first action plan step dealt with our recommendation to prepare accurate and complete agenda items. We found that the housing division has provided training, education to staff along the lines of what Ellen each of those staff are now required to sign annual assertions acknowledging the requirements to prepare complete appropriate agenda items. We also looked at a new loan that was presented to, special project loan that was presented to the City Commission since the initial audit, and reviewed the circumstances regarding that, and we found that the agenda item for that was appropriate and complete, so we consider that step completed. The second step related to our recommendation for the Housing Division to define what a special project loan was and to create a special projects committee for the purpose of reviewing future loans and making recommendations to the City Commission. That step has not been completed, but management within the Housing Division is in the process of defining what types of loans will be under that policy, and they're also in the process of developing a structure for that special projects committee. They plan to include appropriate city staff outside of the Housing Division, and also include a non-city volunteer that has commercial lending experience. And once that committee is in operation, they will review loan requests, and their recommendations will be part of what's presented to the City Commission. The third action plan step dealt with our recommendations that future loan authorizations should be prepared in accordance with the specific City Commission authorizations. I don't, if you recall, one of the contracts that was executed after the City Commission authorized a loan several years ago, the contract provided for those funds to be used for something other than what the Commission had authorized. And again, we reviewed the loan authorization for the contract for the loan that was authorized subsequent to the initial audit, and we found that it did conform to the City Commission authorization, so we consider that step to be completed. The fourth step dealt with our recommendations for future loan contracts to include provisions that require the loan recipient to provide proof that the advanced funds are in fact used for the intended purposes as provided by the Commission authorization, as well as contractual terms and conditions. Again, in regard to the loan that was authorized and executed subsequent to the initial audit, we found that the contract requires the recipient to provide invoices, receipts, purchase contracts, and any other appropriate evidence to clearly demonstrate that the uses are proper, and that has to be done before the funds will be dispersed. In addition, the contract provides for a city inspector to go on site and actually validate the work is performed before those funds will be advanced. And that work relates to the rehabilitation of a piece of property for affordable housing. I promise you, these are going to go a little bit faster as we move through here, but the fifth action plan step dealt with our recommendation for the Big Bend CDC. Was for the city to determine if the Big Bend CDC was in possession of any unencumbered properties that could be mortgaged as a security interest for the one loan that we identified that was supposed to be collateralized but was not. And the outstanding balance on that loan at the time of the initial audit was $180,000. We found that the city was successful in obtaining a mortgage on the property. In fact, it's the property that houses the Big Bend CDC. That's known as the Tishberg House. It's a historical house located in the Frenchtown neighborhood. So that step's been completed. The sixth step dealt with ensuring that collateral is provided for future loan agreements in a timely manner. Again, for the one loan that was authorized subsequent to the initial audit, we found that the contract does have terms that requires that recipient to secure the interest by providing the city mortgages on the properties that are being rehabilitated. And those mortgages are required prior to the city advancing funds. We're considering that step to be in progress, and because we're going to wait and follow up to see that those mortgages are actually obtained once the rehabilitation starts. seventh step dealt with the housing, our recommendation for the housing division to annually inspect all collateralized properties to verify that they have been properly maintained. We found that has been done, so we consider that step to be complete. The eighth step, which is the last one dealing with the loans, relates to our recommendation for the housing division to verify that the properties that are mortgaged as collateral are properly insured. We found during the initial audit that the city had not determined that insurance was being maintained on those properties. We were able to validate independently that it was maintained. But nonetheless, we're recommending that the housing division start tracking it, and they've started the process for doing that. It's not done, so we will follow up on that in our next follow-up to see that it is done. The next three action plan steps dealt with the grants, and it dealt with the city's efforts to recover the questioned or unallowed costs that we had identified in the initial audit. This step has not been completed. The Big Bend CDC executive director requested additional time to see if it could come up with support. We noted in the follow-up report that they'd already been given 9 months, but nonetheless, they have been granted that time, so we will follow up on that in our next follow-up to ensure that the city has taken action on that. The 12th step dealt with our recommendation for the housing division to enhance their reviews of reimbursement requests submitted by the Big Bend CDC to ensure that the costs are substantiated, allowable, and appropriate. That has been done. The Big Bend CDC submitted a $37,000 reimbursement request subsequent to the initial audit. The housing division is going through that in detail, but more importantly, the housing division is not going to pay those funds until everything else has been resolved. But their review process has certainly been enhanced. The last two steps pertain to enhancing the monitoring and oversight processes for both the loans and the grants. Those enhancements are considered to be in progress. The housing division is in the process of identifying all the contracts and projects that should be monitored and updating their schedule to complete those monitorings. In addition, they're going to have to fill a vacant position that was established, or excuse me, had already been previously established, that conducted those monitorings. That position became vacant during the audit, or either right after the audit. The last thing I'm going to do is remind you of some of the major corrective actions that were done that were reported in the initial audit that were not part of the action plan. The largest of the outstanding loans, which was about $700,000, was recovered by the city immediately within a week before we issued the report, due to efforts by the housing division and the city attorney's office. In addition, the Big Bend CDC committed a new revenue stream to paying off one of those loans, which is coming from developer fees for a project that's been started in Frenchtown. And since the initial audit, a total of $19,000 has been collected on that. And 2 new promissory notes were executed with the Big Bend CDC that provide for the remaining outstanding balances to be paid no later than at the end of calendar year 2018 for one of the loans and the beginning of, I think, January 19 for the other loan. So a lot has been done. There's more to be done, and we will follow up again as of September to see what's been done.
Questions from Mr. Fletcher? Ms. Phillips?
I appreciate the city and you moving forward, and Mr. Shelley, based on your conversations with Julie and doing this audit. And it sounds like you have gotten a lot accomplished. I do have a couple of clarifications. When do you anticipate, I'll just give them to you all at once. When do you anticipate the definition of special projects? With regard to the insurance, what if there's a lapse? Is there corrective action that the Big Bend will take, or the city will take, if there is a lapse in insurance on any properties? And a comment. The money, the unallowable expenses, at this point, they've had 14 months to find their receipts. In September, it will be 17 to 19 months to find the receipts. And I think that's a long time to look for receipts. And that's I'll just make that comment.
Well, I'll take those kind of reverse order, I guess. I think it's been about a year since we made the initial request and gave them the opportunity. We pointed that out in the report, and I think by the end of this next follow-up period, the city will have made a decision and acted on that. In terms of the special project loan definition, is that was the first question? I really anticipate all these to be done by September 30. Now, that doesn't mean they will, but based on most of our follow-ups and the importance of some of these action plan steps and what we've seen, and in my discussions with the applicable management, I expect that most of these, and not all of those, are going to be done by September 30th when we follow up again. So,
Insurance lapse. Insurance policy coverage.
well, there's been no lapse. I mean, as I said, we did find out that the Big Bend CDC had maintained the required insurance. The city just had not been tracking it, so we took some effort on our part to see that the insurance coverages were there. So our recommendation there is for the city to do a better job, or to track if they're supposed to have insurance, to make sure that the insurance is there. If there was a lapse, if we did that, the purpose of doing that is to see if they're not maintaining the required insurance, that we can go to them and say, you've got to insure this property to protect our interest in it.
And my
That
question
would be
is,
the action that would be taken.
right, my question is, what, if there is a lapse, what would the city do about that? Or do you know? I mean, maybe,
I don't know what the city could do if it didn't own the property, other than, I guess, the city could elect to buy insurance and insure it itself, but I would hope that we would not do that, that we would require the Big Bend CDC to do that.
Other questions? I actually had the same comment about the length of time looking for receipts, but I was going to ask a slightly broader question. Is that issue of not being able to produce receipts for substantial amounts of money after months and months of looking, is that something that you see in other areas, or has that been unique in this audit?
I think it's somewhat unique, and let me back up. Let me give a little perspective on that. And we started, I think it was last July. It was the first time we went over there to try to get evidence of costs that we were questioning. And to give the Big Bend CDC credit, they did come up with some stuff. They did come up, when I say stuff, they did come up with support, legitimate support. And we met with them multiple times, 4 or 5 times over the next 3 or 4 months, all the way up until a few weeks before we issued the report. We gave them time to find documentation or go to the vendor to get documentation of whatever it was that we were questioning. And they did come up with some, but each time we met, it was less and less that they were coming up with, because we had the same questions pretty much the whole time. I think we gave them ample opportunity. I think management decided when they came and said, we want one last time to see if we can't come up with some of this support. They felt obligated to do it. They weren't, and management wasn't there with me in all these meetings. It was me and myself and my staff. So, but I think enough time's been given, and I think management agrees, and that's why I say I think by September 30th we'll know, and action will be taken on these steps.
Fair enough. Other questions? Thank you for spending your evening with us, Mr. Fletcher.
Getting to be too much of a
Too much of a good thing. Okay, is there anything, I'll try to ask this at every meeting, is there anything that any board member wants to see placed on a future agenda? Ms. Phillips?
I would like a report from Mr. Fletcher in October
What?
The follow-up.
on the
this.
follow-up.
Okay.
September? When is that?
October.
October.
Or,
Whenever it's
Well-
available, we'll invite you back, Mr. Fletcher.
We have to work the follow-ups in our schedule. We look at it, we won't do it before September 30th because they have until September 30th to complete the action plan steps. It could be towards the end of the calendar year before we get to it. Sometimes it's the first of the next year, but
at your earliest
Certainly.
convenience.
as soon as it's done.
Wonderful, thank you. Anything else for a future meeting? Public comment on non-agenda?
Mr. Chair?
Oh,
Just a question, I don't know what, if it's goes on the agenda or what, but in addressing citizens' concerns, what do I tell them that the ethics board is done or going to do on the allegations that we've had in the past, especially I'm referring to the one on the mayor?
well, we've had, I think we closed that
Is that closed?
as not having jurisdiction. So right now, we have one issue that's sort of outstanding that we're holding till next month. We'll see if we have additional information, and see what the board wants to act on. And I will be working with Julie before then. If it looks to me like we need to go into a shade meeting, just like on the last one, I'll just put us in a shade meeting. I'm not gonna ask you guys, I'll just do it. If it looks like there's something to go in the shade for. I think one of the things that we may want Mr. Currington to ponder, if he's, yeah, okay, just making eye contact, is if we did take action on something that was not within our jurisdiction, are we getting sued over that? I want to be careful that we don't do something unethical, because I think there is some level of frustration. Just thinking about consequences we might face if we were to do something, or if we were to, I don't know how to describe exactly, but I'm hoping I'm bumbling my way into a question here that Mr. Currington can interpret. I know he's had some clients who are less eloquent than I, so he has good practice with turning bumbling into a legal question. Any other public comment? Okay, well, I believe we are good. Our next meeting is Tuesday, July 18th, 2017. It says on our agenda from 4 to 7. We may move that to 5 to 7 if depending upon what's on the agenda. I'm going to try to push our start times back a little bit if it looks like we can get through in a 2 or 2.5 hour meeting, just because I think 5 is a better start time than 4. Mr. Brown?
Chair, I will then request the excusal from that meeting. I'll actually be down in Key West during that day, so I won't be here.
Okay, so you'll be excused for that meeting, okay? We will do our best to represent you. And with that, we are adjourned.